Hi, all. Today we're talking about race and sentencing and how discussions over jury and judicial power applies when racial bias is being found either intentionally or in its impact on the results of our sentencing systems. Now, jury selection procedures vary widely by state. There's usually some kind of random selection based on those registered to vote, driver's registration data, and other sources. Some people are stricken for lack of qualification to serve for a range of reasons or get excused by request. But who serves on the jury has great impacts on defense results. And there's been challenges under the Sixth Amendment right to jury based on the idea that people's peers were being excluded from the jury. And so the question is under what's called the voir dire process, where jurors are questioned by attorneys to reveal facts about why they might not be able to be like fair and balanced in their like jury deliberations, they can be challenged for cause, meaning the judge says they have an inherent conflict of interest, or be challenged under some set number of what's called preemptory challenges, where either the defense or the prosecution can just get rid of anybody for any reason or no reason at all. Now, the way this played out in various cases, back in 1970, you had the case Carter v. Jury Commission. And unlike a lot of other cases, which had been just about individual jury problems where like individual juries were challenged, this case was one where the whole local Alabama process of picking people to serve on juries was challenged. A federal court found in this area of Alabama that local clerks had essentially ignored the law in not looking at current voting registration and instead just looked at older lists and then added people only on quote unquote recommendations. There was no process to systematically add Black residents to jury rolls. And it's important to look at the timing here. In 1966, and remember, this is a year after the Voting Rights Act of 1965 had been passed, blacks were three-quarters of the county involved, but only 7% of jury lists. 50% of white males were on the jury rolls, but only 4% of blacks. Women would only be added in 1967. Important part of the debate on juries is in many areas, women got onto juries almost as late or even later than many black men. Now, by the time this decision happened, blacks had become up to 32% of jury rolls, but it was still far short of their proportion of the population. So the legal issues in Carter v. Jury Commission was how do we decide that a whole system is is biased, and what are the proper remedies for a judge to make in dealing with these procedures? The appellants, meaning wanted the procedure to be essentially abolished altogether. And, you know, essentially they want the defense had argued that, they were only putting on people under the law who were generally reputed to be honest and intelligent and esteemed for their integrity, good character, and sound judgment, which is where a mass amount of bias was made on excluding people. Now, the Supreme Court wouldn't invalidate that provision. They said states were free to pick their own jury selection, including excluding people based on age, education, and even character. But they did say that the system in this case was biased, and they left it to the courts to shape what's called injunctive relief, essentially, the courts ordering administrative groups to change their practices where they saw proof of racial discrimination involved. The question was leaving that statute in place was still going to leave bias to play a role, but the hope was that courts could, on a case by case basis, exclude processes that were proven to be racially discriminatory. But that gets us to Batson v. Kentucky, a case quite a few years later in 1986. This was a challenge to the use of preemptory challenges that were being used to exclude black juries. In this case, defendant indicted on burglary and other related charges. The prosecutor used preemptory challenges to exclude all four potential black jurors. And the defense sought to dismiss the all white jury for violating the Sixth and 14th Amendments, but were denied at the time, so they appealed afterwards. The defendant had been convicted on both counts. The Supreme Court did find that this violated the Constitution. You know, in one past case, they had found refusing to seat juries based on race violated the Constitution, but they hadn't challenged preemptory challenges. Now, while prosecutors, the majority said, could use discretion to block jurors, they couldn't use race as, quote, the sole criteria to do it, meaning race could influence their views, but they had to have other reasons for doing so as well. Um, that had been a problem in the past, is that left so many options for prosecutors to find some reason to pair with a racial bias to exclude people. So the court created a new standard for racial exclusion. They would look at comments made in voir dire, and if they saw racial intent to exclude jurors, only if the prosecution had a neutral explanation for challenging black jurors would they allow it to stand. They couldn't exclude jurors, for example, because they thought the black jurors might favor people of the same race. That was the core of this. Now, Justice Marshall in concurrence said, this is all well and good, and I'm glad we're going to challenge, discriminatory preemptory challenges, but there's so many ways for prosecution to manufacture so-called neutral stances while still being biased. Justice Marshall thought they should exclude preemptory challenges altogether. And there's pretty strong evidence he cited from California and Massachusetts to show that just reviewing preemptory challenges would be insufficient, since prosecutors can keep exclusions to what Marshall noted was a, quote, acceptable level. Now, Justice Burgers and Justice Rehnquist in dissent said, racial bias is not a problem as long as it's applied to both white and black jurors. Berger was very much, preemptory challenges are based on a hunch. You can't really look at them as rational decisions. This would essentially kill preemptory challenges, Berger argued, which of course Marshall would have been fine with. Rehnquist was like, look, as long as you exclude blacks when it's a black defendant and you also exclude whites when it's a white defendant, it's all fair, not looking at the different proportion of whites and blacks in many populations. But Rehnquist was, hey, race is a fine proxy for likely jury bias. So that was the dissent in that case, but it did show the problem. And as you'd see in the other case that was attached, he's like, the Supreme Court is pretty much held to the idea that where you can show that the prosecution was clearly motivated by racial bias, they would strike down exclusion of blacks from the jury. But still, as long as prosecution is not clearly articulating racist motives and can come up with other reasons why they're doing so, still allows a large realm of bias in the whole system. And that gets us to McCleskey v. Kemp, which is just a year actually after we look at Batson. This is 1987. And this was a case that looked at what do we do when we see that the results of the jury system is clearly racially disparate results. In this case, they were looking at the state of Georgia. And there they had a large series of reports done looking at who was being given the death penalty and who wasn't, what was the race of the defendants, and also, and this was critical, the race of the victim. 2,000 murder cases were reviewed from the 1970s, and they found that a defendant killing a white person received the death penalty in 11% of cases, but those killing a black victim got the death penalty in only 1% of cases. Black defendants with a white victim, they got the death penalty 22% of the time, while a white defendant with a white victim got the death penalty 8% of the time. The white defendant with a black victim got the death penalty only 3% of the time. And interestingly, black defendant and a black victim, death penalty only 1% of the time. The main point was overall, the race of the victim often showed the greatest racial disparity. But for those who know statistics, that study also used what was called regression analysis, looked at 39 other non racial factors just to see if there were other things beyond the statistics. And they still found that defendants charged with killing white victims, holding all other factors equal, were still 4.3 times as likely to receive the death penalty as those killing a black victim. And overall, black defendants were about 10% more likely to receive the death penalty as other defendants. You know, the Court of Appeals in this case accepted the jury's finding and said it couldn't meet constitutional standards and was a violation of the Constitution for the Georgia death penalty system to be allowing such racial disparity. Now, in this case, 5-4, court ruling by Justice Powell, he said, look, in an individual case, and this was a case of an individual defendant saying, this system is so racially disparate, you can't convict me individually. He said, look, McCleskey, the, the defendant, had not proven discriminatory purpose in his case. Very important emphasis. And I have to say, in this case, it was a reasonably gruesome murder of a police officer. Not a great case to bring to court in almost any circumstances. But in this case, essentially, Powell says, look, I'm pretty sure this guy's guilty, so I'm not going to knock it out just on statistical evidence. But the problem is, as he notes, trying to prove bias according by an individual jury is very hard because juries do not publish their deliberations. You don't really allow for that. So it's not clear how Powell is going to allow any challenge to court cases despite the statistical analysis, which he pretty much accepts is very solid. He rejects this overall challenge to the death penalty, but says, look, discretion's always going to happen in sentencing, and there's going to be disparities. And the problem, and I think this is the heart of it, is if there's racial disparity in capital punishment sentencing, and we extended this idea that we're not going to allow disparity in sentencing, we quote, would soon be faced with similar claims as to other types of penalty. And you could see the whole system of sentencing in the nation come apart, which I think many of those challenging the disparity might want to have happen. But he is like, look, if we go down this road, there's not a simple endpoint. He argues that any issues of racial disparities should be left for the legislature to fix, not for the judiciary. Courts can't do it. Legislatures are much better at statistical analysis. Now, in the Brennan dissent, joined by Marshall and Blackmun and Stevens, at least in part, he notes that first, Brennan, who generally was against the death penalty to begin with, says, look, at least as far as the death penalty, this kind of disparity should mean we should abolish it in this case. Race obviously has a large effect. There's a higher risk of wrongful conviction when there's this kind of bias. And he notes there was a history in Georgia of a separate criminal justice system for white victims versus black victims. Given that racist history, if we see the disparities continuing, we should use that as a basis for finding racial intent by the legislature that this disparity has continued. And he notes that Powell's fear that they might have to extend it to other areas of sentencing, well, that quote seems to suggest a fear of too much justice, Justice Brennan said. But he does note if you're afraid of it going too far, the death penalty, Brennan notes, is unique and needs to have a much tougher standard of proof, and any kind of racial disparity should call for halting it in the face of this kind of evidence. And he notes that given if you allow this case to stand, defense attorneys are going to look at those and say, look, you killed a white person, you better plea because you're much more likely to be convicted, while those killing black victims might risk going to court. That, in a system of plea bargains, this creates a standard for discussions amongst defense attorneys and prosecutors that are likely to even breed more disparity. Now, Blackmun has an interesting dissent. He notes, look, the problem here isn't the jury. We can't look at how juries make their decisions, but we can look at how prosecutors choose to bring cases, how they decide to pursue it. Do they ask for the death penalty? Don't they? This is a much more accessible set of evidence. And he notes that there is evidence from one assistant DA who testified that they had no training, no guidelines on how to seek indictments for murder. That encourages discretion and uneven treatment. Think of the challenges we saw in Floyd to discriminatory policing and stop and frisk. Blackmun's calling for something similar, where there is no evidence of negligent training and negligent, you know, and disparate treatment. That's the basis for the courts intervening to make sure prosecutors have a set of guidelines that are clear and non discriminatory. And he says, look, put it on the state to explain, give a neutral explanation for these discriminatory results. And that's how the court has generally approached claims of discrimination in other areas, and why the majority in this case didn't go back to saying, look, have the prosecution explain why they're getting these discriminatory results. But I think the important thing that Blackmun wanted to look at here is creating more transparency by how the prosecutors are making their decisions. If you remember, he had a similar approach to trying to make sure plea bargains were, and how those were being brought by prosecutors, was also more transparent. So this was a theme by Blackmun, to make the discretion of public prosecutors more transparent, more obvious to defense attorneys so that they could challenge it. Michelle Alexander also comments on McCleskey v. Kemp and notes that given this amount of statistical evidence, once Kemp came down, it was very hard to see how any racial bias was going to be challenged in the courts. Like, prosecutors aren't going to admit bias, juries, it's almost impossible to identify it. And she notes if McCleskey's evidence was not enough to prove discrimination, what are you going to get any clearer evidence? Now, given also that defense can't actually do discovery from prosecution regarding charging patterns and motives, the court had actually given defense no ability to challenge and find the evidence of bias that might allow them to look at an individual case. So they can't get discovery in individual cases against prosecutorial decisions, and they can't bring in evidence of the overall results, which is a bit of a catch-22 for them ever proving discrimination. So that is the overall stance and history, at least of a large area of racism and sentencing. And it creates a pretty bleak set of options for defense attorneys on how to challenge it, which is the main point that Alexander makes in this. Anyways, see you in the next class.